In a previous video, I explained how the police have the power to pull over vehicles without reasonable suspicion that an offence has been committed. Unfortunately, they regularly abuse this power as a fishing expedition, because once they've stopped the vehicle, they'll try to find a reason to justify that stop. If the driver hasn't committed any traffic offence, the police will look for defects. Failing that, they might turn their attention to the inside of the vehicle. Unlike with the initial stop, the police cannot search your vehicle on a whim. They require a reasonable suspicion that you have a prohibited article in your vehicle. The Road Traffic Act provides no specific power to search a vehicle. Instead, the police rely on a variety of laws to make a search. Most notably is Section 1 of PACE, which gives the police the power to search for prohibited items, and Section 23 of the Misuse of Drugs Act. The most common excuse they use is to claim that they can smell cannabis from inside the vehicle. Or they might claim they saw the driver throw something out of the window or attempt to hide something as they approached. These are well-worn, pre-rehearsed excuses and the precursor to an illegal search. Here are a few more examples of unlawful searches. The police want to search your vehicle because it's been stopped and searched before. They stop and arrest you for a summary offence such as speeding or common assault. You refuse to answer questions about where you're going or what you're carrying in the vehicle. You have rowdy passengers in the vehicle. You're driving late at night in a crime hotspot. You refuse to take part in a vehicle census. If you are subjected to an illegal vehicle search, don't waste your time trying to resist. Video record everything that happens. By all means make it clear you don't consent, but the best place to fight the police is from the comfort of your own home with legal letters, not being dragged through the shattered side window of your own vehicle. Objection is better than ejection. Although it's fair to say damages for assault and battery for being dragged from your vehicle would far exceed that of trespass of an illegal search, such as in this case where the driver sued the police for an undisclosed sum for excessive force. But whatever that sum was, you can be sure it's nothing in comparison to the £430,000 the officer in this video was awarded against South Wales Police for hurt feelings when the video went viral and allegedly made him a laughing stock among his fellow officers. The majority of all civil claims against a force are brought by police officers, not members of the public. The police do have powers under Section 18 and 32 of the Police and Criminal Evidence Act to search a vehicle for evidence in relation to an arrest that's been made for an indictable offence. But again, they require reasonable suspicion. They can't just search a vehicle because you've been arrested and they're hoping to find something else to prosecute you for. This is precisely what happened to a client who I helped sue Thames Valley Police, who conducted an illegal search of his vehicle. The client found himself in police custody after an altercation in a pub. He was arrested, held in custody and subsequently released without charge. When he returned to his car, he found it had been ransacked. The contents of the glove box was strewn across the footwell and his private hire licence was missing. When he reported it to the police, they said that the arresting officer had recovered his lost keys from the pub and had searched the vehicle to find out who the owner was, presumably after trying the key in every vehicle in a 100-metre radius until he found one that fit. Just like Cinderella. In reality, the police searched the vehicle in the hope they could find further evidence of wrongdoing to punish the detainee. As soon as they found his taxi licence, they contacted the licensing authority and had him suspended from his job. The police just won't accept that it's the court's job to determine punishment, and they'll take any opportunity they can to punish people they arrest, even if it means destroying their entire livelihood. The officer changed his story twice as to why he searched the vehicle, and the police complaints process typically backed him up all the way. But this infantile excuse-making was no defence to trespass, and the police lawyers knew it. So when they were presented with a letter of claim, they agreed to pay damages right away. Unfortunately, trespass is regarded as a lesser civil wrong by the courts and it attracts paltry awards. In this case, no more than £150 was agreed. If any damage had been done during the trespass, then the compensation would have been far greater. Nevertheless, civil claims remain the only effective way of holding the police to account for these types of abuses of power. The police complaints process is totally biased in favour of the police, and it is designed solely to discredit the complainant and excuse the officer of all wrongdoing. The county court has a very different attitude to civil rights, and unlike with the criminal courts, the police are not regarded as superior witnesses where their evidence is worth twice that of a member of the public.